Welcome everyone to the third meeting of the Senate Judiciary Committee. I would ask all members and guests, as always, please silence your cell phones. Mr. Secretary, please call the roll.
Senator Carroll. Senator Deneen.
Here.
Senator Neal. Senator Nemes.
Present.
Senator Reed.
Here.
Senator Stivers. Senator Thomas.
Here.
Vice Chair Wheeler.
Here.
Chair Storm.
Here. Appears we have a quorum present and are duly constituted to do business. Do any members have a guest they'd like to introduce?
I do. I haven't. I know we don't have pages, but what I've done in lieu of that is have what I call the shadowing league. I have Mr. Tyler Overton here today from Lexington. He's going to shadow how the legislature works. And, this is a great day for him because I have a number of committee meetings today. I want everyone to welcome Tyler Overton.
Welcome, sir. All right. First on our agenda, we're going to skip around a little bit. We're going to call Senate Bill 122, an act relating to alternative sentences, sponsored by Senator Julie Rocky Adams. And Senator Rocky Adams is stuck on the interstate. However, we have Representative Wilson here with us, and I did co-sponsor the legislation. So at this time, we do have some individuals that have signed up to speak too, so we'll make sure they have ample time.
Wait.
Oh, okay. Okay.
So at this
Sorry.
time, if you would, I'm going to go ahead and start it. Members, you'll see in your packet Senate Bill 122, and basically what this does is offers opportunities for certain individuals, a small class of individuals, to seek this relief. It requires a motion, if I'm not mistaken, Representative, of the defendant to file. There's some steps that would be undertaken by the defendant, and then the court would have various steps that they would engage in. Is that accurate?
Yes, Mr. Chairman.
And if you want to go ahead and explain the intricacies of the bill.
Absolutely. So I'm Nick Wilson. I'm the state representative for District 82. I filed this bill last year, passed through the House unanimously. And so we decided to file it again this year, and Senator Rocky Adams filed the Senate companion. The reason I filed it is because, especially in Appalachia, I'm a kid of the 90s. In the 90s and 2000s, the OxyContin prescriptions were out of control, and to put it bluntly, it destroyed our society, the familial structure, which is the backbone of our society. So here we are 20, 30 years later, still dealing with the fallout of this opioid epidemic. I was a public defender, I was a prosecutor, and actually, if you live in Eastern Kentucky, just a citizen with family and friends, you see people all the time who want to get clean, they're ready to get clean, and they simply don't know how. And I've seen to where some people get to that point, and the driving factor is their children. They want to be a parent, they want to be a family, they just don't know how to be that parent. If you're in the courtrooms like I am, you see children getting raised by their grandparents, aunts, uncles, great-grandparents. We see it all the time. There's been this focus that has been successful on these folks when they're in probation or diversion or even in prison. There's been this focus on job training, drug court, inpatient drug treatment, outpatient drug treatment. And what this bill does, it adds parenting classes and family counseling to that list of those successes. I have a guest here today. If there's time, we may have her speak, but she can attest that she was sent to prison and received these parenting classes there. And she's even got her son with her today, who's now a nice grown young man. So that's the reason for the bill, to go through the process of what happens, or I guess to explain more of the process. It's upon a motion by the defendant. So it doesn't automatically trigger. The defense lawyer has to make a motion, and they have to show that they're the caretaker. And then it's up to the judge to consider. So if you're in criminal law like I am, I've spent my career in criminal law, you know that most of the time there's a guilty plea anyways. And so that's something that's going to be considered, these classes, that's something that's going to be considered in a plea bargain. So most judges allow the prosecutors and defense attorneys just to figure out if they have a plea, they basically accept that plea. Where this could come into play is, I'm guessing, on a revocation, but what I'm imagining it actually happening is when a defendant makes a motion and it's up to the judge, they're deciding between prison or probation. And so if it's a caretaker, meaning a parent, so we changed the word from parent because lots of people are parents. This isn't for every parent. This is for a parent who's trying, who wants to be a caretaker, who wants to raise a family. So then the judge makes a determination. They decide if they decide probation, then it can add these classes onto it. But that's the gist of it. Like I said, I have guests here for testimony. I'd be happy to answer any questions, just whatever the chair allows or would like.
I see Senator Adams walking in at the moment, just in case she has any follow-up comments she'd like to make on the spur of the moment.
What he said is great.
All right, I think we have a couple questions for you at this moment. Senator Wheeler?
Thank you, Mr. Chair. And I am going to vote for the bill today, and I want to say I've had some conversations with the sponsor, and she's been very open and amenable to trying to make this something that actually works. Now, I won't say that I don't have some concerns on this bill, because let's just say hypothetically, I'm a drug addict, you're a drug addict, but you have 2 kids and I don't. We are somewhat creating a 2-tiered system of justice, because you're going to be eligible for a program that keeps you out of the clink, while myself, who perhaps arguably is more responsible because I've not brought a bunch of people into the world that might be on social services and everything else that are having to deal with your malfeasance or whatever, I got to go to jail, but you don't. And that does create some concerns for me. And I guess I would probably argue that maybe the bigger issue is not that the drug epidemic. It caused a lot of problems in Eastern Kentucky and everything else. There's no doubt about that. I've lived it too. I've got a brother and a sister who've both problems. But, I guess it's probably really more of a symptom of just the overall decline and to some degree the court system pulling morality out of the school systems and going to a system of relativism that's really just caused the decline in Western civilization in general. But that being said, I'm willing to give this a chance. I'm going to vote for the bill, and hopefully it'll work out.
If I may, Mr. Chair.
Sure.
I simply don't agree with the argument of a 2-tiered system. Judges decide on a case-by-cases all the time. This is just another factor that they're going to take into play. And I agree with you on the morality part. That's why the family is the backbone of a godly society. We have to figure out how to get the family back together in this Commonwealth, especially in Appalachia. And that's the main reason I filed this bill. And actually, House Bill, I was able to get number 464, and Ephesians 6:4 is the reason I got the number. And fathers, do not provoke your children to anger, but bring them up in the discipline and instruction of the Lord. The family is the first step to getting back to where we want to be as a society.
Senator Carroll?
Thank you, Mr. Chairman, and I appreciate the presentation of the bill. And for the committee's knowledge, this bill came through Families and Children's Committee last session, and I worked. There was a Senate committee sub that I worked hours on with Judge Sumi, and I spoke with other judges. I spoke with representative for the Commonwealth attorneys, and the overarching view for this bill was that it simply wasn't necessary. It was a solution to a problem that didn't exist, and all of these options are already open to the court. Through the pre-sentence investigation, it is determined whether or not that individual is a parent, and that is considered by the court. And there was some concern that really all this was going to do would be to add another hearing to the process to a court that is already a court system that is already overloaded. I could not get the votes in Families and Children Committee to move this bill forward. And just so the committee knows, those were the responses through the contacts that I made with Judge Sumi, other judges, My judge at home, I also spoke with, and they felt that it simply wasn't necessary, that all this is already available and already takes place within the system.
Mr. Chair, if I may, I think that Brittany and her son would probably disagree that this is not necessary. It may not feel necessary to judges, but the folks that are out there living this, it's necessary. And it's not available. It is available in prison, and that's where she was able to take advantage of that. Why can't it be available at sentencing for people who are getting probation already?
Senator Thomas.
Mr. Chair, I would like to weigh in on this, being someone who's certainly not shy. We already have a two-tiered system in our society with regard to families. I mean, in our tax policy, we see that. In our school system, we see that with regard to our free and reduced lunch. We have historically and often, given benefits to families who have children, and I think that's a good thing. I do agree with Representative Wilson with the notion that the family unit is critical, and if we're going to talk about saving society and further society, it has to start with making sure the family unit is strong. I have some bills, as you know, that I want to get passed here in Judiciary that talk about passing on family wealth and generational wealth. I think we should always prioritize and give credit to the family. I mean, all of us have children. All of us love our children. All of us want to do the very best for our children. And so we should transfer that to say, okay, we want to do the best for our children. We want to see everybody else do the very best for their children. People do make mistakes. Nobody's perfect. And yes, you do have parents, and Senator Wheeler's right, who have children who get on drugs and don't do all they need to do. But if they want to come back and correct that, we ought to be sensitive to that. So that's my 2 cents, and I think this bill's a step in the right direction.
Thank you. I just have a couple questions of my own. Just if you would turn your attention to. Let me find it. So, page 2, beginning at line 18, violent offenders are excluded under this, correct?
That's absolutely correct.
Okay, I just want to make sure the public
Yes.
is aware of what's excluded. And then we have, subsection B, those individuals, that's basically domestic violence type actions, is that correct?
That's correct, and that's also to ensure that some things that are technically not considered violent offenses, we're still trying to catch those too.
Sure.
Make sure nothing even remotely close to violent gets this opportunity.
And then subsection 3 makes sure that if the victim is a child in the case, that also does not qualify the person.
That's correct, and again, I think that would probably be captured by the violent offender part, but just to make sure, we've got that in there as well.
And then subsection D talks about it also be prohibited if there's a statute that prohibits probation, shock probation, conditional discharge. Is that accurate?
Yes, Chair, and that's important, especially when you're looking at heroin and fentanyl charges. This subsection catches those. So those people are, even though they're addicts, they're probably not eligible for this.
And then I want to turn your attention to page 3. This is, I want you to clarify the understanding, or my understanding, beginning on line 8. Walk us through why this is there. Is this something that can be used in family court proceedings where there's conflicting courts or not? One's criminal and one's civil. I think I understand that, you understand that, but so the public understands. Can this be used in another proceeding?
Absolutely not. And we want the language in the bill and the law to be very clear. This has no effect on any other jurisdiction, any other hearing, any other court, not family court, not juvenile court. Actually, Mr. Chair, not even hearings in the same case. If there's a revocation hearing 6 months later, this decision has no effect on the future of that case. This is simply when a judge is deciding prison or probation, to take the family unit into account when making that decision on that day.
Thank you. I don't see any other questions for you two, but we do have some people. I'm sorry, Senator Carroll, again.
Thank you, Mr. Chairman. And I don't want it to seem that I'm disagreeing with the premise of all of this. I want to understand. I feel like I'm missing something because the judges tell me that these are all already options, and you're saying that it's not. And I'm struggling with that because I didn't just check with one judge. I checked with a few that told me the same thing, and and the fear is it's just adding yet another step, and they already have that information through the pre-sentence investigation. So help me understand what am I missing here? Are you saying that they can't give probation and they can't do alternates with programs if these programs are available in that jurisdiction, which some aren't? So help me. You're saying this is not happening?
I don't think that these programs are available until you're in the Department of Corrections and you're in prison.
Okay.
That's a big part of it.
If they're not available, how are they going to be given as an alternative if they're not in that community?
Well, they'll have to become available.
Okay, well, that's something that you left out of this in the conversation, and so that's something that really does need to be determined on this. But within the scope of the programming that is available, are judges doing probation and sending folks through those programs? Parents, mothers?
There is probation already. We need to put a focus on this consideration. This consideration is important enough to be a focus. Yes, I know I get a 35-page pre-sentence investigation report that somebody may or may not read. We're trying to get beyond that. We're saying this is too important to be one tiny section on a 35-page PSI report. It's more important than that.
And I just want to reiterate, I mean, at the end of the day, it does nothing with judicial discretion. If the judge decides that they don't want to consider this in a case, they don't have to consider this in a case. But one of the reasons I'm so passionate about this bill is because having worked in the child welfare space for a long time, I see that there are creative things that we can do to help these families while they're in crisis. I mean, the first thing that whenever I talk to foster kids, the first thing that these foster kids say is, I don't want to be in foster care. I want to be back in my home, and I want my home. I want you to help me to fix my home. There are so many different ways that we can help those families that are in crisis rather than incarceration. And if this works for 1 in 100, then good for us, because I think we're doing the right thing to heal that family and to have them have a more stable environment.
Mr. Chair, and if I may add, my judges are for it. I hear from judges that are for it. So this sentiment that everybody's against it is just wrong. And even if that was true, I'm not here to make policy specifically for judges. I'm here for families. If they want to make policy, they can come wear the pin. This is our job. We are the legislators.
Mr. Chairman, if I may, I don't disagree with any of that, and I guess it's with a lot of the things that we do, we indicate that judges aren't doing the right things, and I feel like they are. And there's another thing to consider on this, and from being on the child fatality and near fatality task force, and hearing the cases that we hear every meeting on this, there are some parents that need to reach that rock bottom before they make any changes in their life. And you can do all these programs in the world, and that's not going to work. And if we pad those rocks, sometimes those folks that need that to make changes in their life may not get that opportunity. And sometimes that's just as effective as counseling. And I say that from seeing this through 24-year career in law enforcement and from these cases that I hear where parents are repeatedly reunited with their kids, and then the next thing you know, we're hearing a case on a fatality or near fatality related to those families, specifically with substance abuse. So I don't disagree with anything that you're saying. I guess I'm speaking for the judges and some of the Commonwealth attorneys from the conversations that I had, and I think everybody has the same goal. There is no indication with some of these programs that there's a requirement to start these programs. So that's kind of unclear, and I really do believe that these things are happening. If a judge hears the case and they think that it's based on all the facts and there are programs within the community, they are going to give that person a chance. And you all know as well as I do, people get chance after chance before they're put in jail. That's not the priority in our court system today. And this is almost like an indication that those things just aren't happening, and you're trying to force a judge to consider something that can guarantee that every one of them considers in every case that they hear. And I'm not being disrespectful. I think we're all on the same page. Again, I'm not sure this is necessary.
I think we are on the same page. That's why I don't understand a lot of what you're saying. If they're already doing this, then they love this bill. It helps. It's exactly what they want.
Thank you, Representative. At this time, Judge Ward has signed up, so we've been talking about what the judges think, and she is a judge, so she wants to come up here and speak. And if you get once you get there, if you could identify you and your guest, and you have the floor.
So I'm Julie Ward. I'm a circuit judge in Campbell County. I've been on the bench for about 22 years now, just a little bit shy of that. And with me, I'll let Jeremy introduce himself.
I'm Jeremy Maddox. I'm circuit judge.
Please turn on your microphone, please.
I'm Jeremy Maddox. I'm circuit judge in Bourbon, Scott, and Woodford.
So I want to say thank you to Senator Carroll. He did voice a lot of things that we talked about last year when this bill came up. We sent out an email to a lot of circuit judges to get their opinions on it, both family and circuit. And there was overwhelming responses to that. And we haven't had time this year to recirculate the bill and we did recirculate it recently, but didn't have time to get all the comments back. So I'm here today just to talk for myself, because until I get those additional comments back, I don't want to represent that I'm speaking for all the circuit judges. But I will tell you that I agree a lot with what Representative Wilson said in terms of importance of families. I think that you all on this panel and me and Jeremy both, we probably went into public service to serve our communities, to help society, to help people. I know that's why I became a lawyer. I know it's such a cliche statement, but that's just the truth. We want to serve, we want to help. If the idea of the bill is that we would be able to provide some sort of counseling, or we would be able to have parenting classes, and you all would fund that, I'm in. We're all in. We would love to have those services available to us, that if we were going to offer probation, that there would be parenting classes available for people who could and need them and want them. But we don't have those services readily available in all of our communities. And if they are available, they're not free. Defendants have to pay for that. So what you're asking the court to do on one hand is order a defendant to go to parenting classes that may not be available, asking us to send them to anger management classes, substance abuse classes, all these things that may or may not be available, and sometimes at their cost. And if they're not able to comply with the condition that you're asking us to impose upon them, they can have their probation revoked. The pre-sentence investigation report, I don't know a judge that doesn't read their pre-sentence investigation report. It's our duty. It is our duty to read that report, and in that report it tells us the defendant's name, all of his family members, moms and dads, all of their children. It tells us where their children are living and who they're residing with. The defendant has an opportunity to make an offender statement, say whatever he wants. The defendant, if cannot afford an attorney, is appointed one. That attorney can argue anything he wants to us, and they do. They routinely argue to the court that this person is not only a caregiver of a child, but maybe a caregiver of a parent who is going through chemotherapy, or a grandparent, or whatever the case may be. Those are all things that we as judges always consider. When a defendant gets to a point that their children are being removed from their care, then most likely that child is already in the family court system. The family court is already addressing those needs and providing whatever services that are available to that defendant or to that person that's participating in the family court system. Those judges are doing that. This bill does not accomplish that goal. What this bill does, it creates probably an equal protection problem, that two-tiered system that Senator Wheeler was talking about. Because what you're asking us to do is give preferential treatment to caretakers. And then you're not only asking us to do it, you're telling me I shall do it, and I shall have an evidentiary hearing. So at the sentencing phase, we're no longer just going to hear arguments. We're going to be required to have an evidentiary hearing on any defendant who wants to file a motion. And for y'all to think that it's just going to be one or two defendants who are going to do that, it's not going to be the case.
Well, Judge, if with all due respect,
Yes, sir.
I think, and not to cut you off, but I think that may have been, you may have misspoken. I just want to clarify. These would be for individuals that have their caretakers as with a dependent child.
Oh, I
correct?
understand what you
So not
mean.
all defendants, only this section
Oh,
of
I understand.
individuals. I just want to make sure that the
Sure.
record's clear.
What I'm saying is all defendants who want to say they're a caretaker are going to file a motion. And there's a lot of defendants who have children and are going to now claim they are caretakers. So we are going to have evidentiary hearings at a sentencing phase, which means I'm going to have a full-blown due process hearing. Put people under oath and get evidence. You're going to require your Commonwealth attorneys to start trying to dig into whether this person is actually a caregiver or not. The Commonwealth attorney then is going to have to pull all those family records, some of them which are not going to be available to us because they're confidential. Right now, defendants already come into court and they tell us that they're caregivers. They explain to us what's happening in their lives. We already get that information. We duly consider it. There is a way that I think that some of these things can be resolved. Not this bill, not the way it's written. I think that I would strongly encourage you not to pass this today. Let me work with Senator Wilson or Representative Wilson and Senator Rocky Adams and maybe suggest some language that would be more apt to accomplish maybe the goal that I heard them speak about today. But obviously, I respect all of what you do. I know that you work very hard. I know they work very hard. I can see the passion and the commitment to their jobs, and I have that same passion and commitment, and I think my fellow judges do too. So, thank you.
Thank you. Senator Wheeler had a question.
Judge Ward, thank you for coming down. And I actually was on the phone with a friend of mine yesterday, a family court judge who's also served as a circuit judge and was also previously, in his previous life, a criminal defense attorney. So he's really had a lot of, and he expressed some of the concerns that you did as well, and particularly about the lack of access to J cases. And Chairman Storm and I actually held a conference call, and Senator Adams, she's expressed a willingness. She wants to get this right. She has expressed that repeatedly to me, and I know that that's the case. So one thing we in fact did discuss is, and one of the reasons that I'm going to vote for this bill today, is there will be a floor amendment that will allow at least the courts to have access to those J cases, because like you said, they are confidential, but they do need to be in the pre-sentencing report so that the sentencing judge is aware of, of things that they may or may not have, they probably wouldn't have, or at least probation and parole would not have access to. And we verified that with a phone call yesterday that probation and parole does not have access to J cases. I think a judge would, but it would be asking a lot of you to do a major CourtNet deep dive on every single case. So we want to make sure that, I believe judges do look at the pre-sentencing reports. And, in his particular status as both a family court judge and was also substituting as a circuit judge for a while, he said some of this stuff did in fact come up at sentencing, and, where he sits normally as a family court judge, he was aware of some of the J problems when people would make these type of arguments, but a normal circuit judge that doesn't deal with these types of issues in family court probably would not be. So I do believe that is a loophole in the bill as currently written that I think the drafter and Chairman Storm and I are committed to fixing so that, this functions in the best way possible.
The only other thing I would say is, and most citizens don't know this, but probation and parole, just to give you a heads up, if you're a low risk, you only see a probation officer once every 3 months. So when we talk about really follow up and we talk about services and we talk about making sure things happen correctly, you got to start with the idea that you can't see someone every 3 months and expect that you're really providing services to them. If you're high risk, it's maybe twice a month. But if you're a low risk, which a lot of people are, because it all depends on what the risk assessment says, which is just another algorithm that honestly, I could give you a lot of examples why you probably wouldn't agree. You know, the services that you're being asked is who's monitoring this, the parenting classes, how many classes do they have to attend, who's going to offer these things. And again, the evidence you're hearing is just not necessary at the circuit court level. It's duplicating efforts. We have the family courts who are looking at those J cases, making those determinations about who should have custody or not. And now you're asking the circuit court to duplicate that effort. It just seems duplicative, redundant, and unnecessary.
Thank you, Judge. The other gentleman here at the table, do you have anything else to add at this time?
No, I'm just here basically with Judge Ward. It's easy for me to get here because I'm over in Scott County. There's several judges who have similar thoughts on this. I do think she made an excellent point there with this being redundant services. A lot of people that have addiction issues have already encountered family court, do have a J case, they're working a program. They'll come in to court at sentencing or at the plea status, and they'll talk about, it may be part of the plea agreement is that they're supposed to work their case plan through the family court. And so a lot of this stuff is already taken into consideration. It's in the PSI. There's a whole section on the social history. It lists the members of the household. So if for example, if you are a grandparent who is caring for a grandchild, that is in the PSI. That person is a member of your household. It's included in the PSI. It's there. I take exception to the fact that it was insinuated that we don't read them. We do read them. Defendants and their attorneys read them. They're given an opportunity at the sentencing to say, hey, this fact in here is incorrect. We don't believe this is true. They've misstated this, and they're entitled. We can give them a hearing on that if we need to.
Judge, let me ask you. So when that happens, does the court? Because my experience is the court says duly noted, but do you actually make a finding of fact and say, hey, this issue that the defendants pointed out is not correct, and they've raised this issue, so now let's have an evidentiary hearing. You're talking about what you do in your courtroom, so do you do that? And in which cases have you done that in, so I can go back and watch those videos?
Well, most of the time it's something simple like, hey, my address is wrong. This is my correct address. Or now I have this job, and I no longer work at this location where it says I'm unemployed, and I've got a job here now. Typically, I just rely on what they're saying. If the Commonwealth doesn't dispute it, if it's something like that, we just address it, and it's part of the record. But for the most part, we don't run into major substantive issues with the PSI because they're getting the information from the offender. It's not that person sits down for an interview, they provide the answers, and the answers go in there. So oftentimes what it is just there's been a change. That they've gotten a new job, or they've changed addresses. Maybe they moved to sober living, something like that.
Thank you. Senator Nemes.
Yes, thank you, Mr. Chairman. Either judge, if you feel the services are not available outside, can you then not have to release them to do this because there's nowhere to go? And are there services within the jail that you can provide for them? And if I'm hearing this right, that this may clog the court system up with more?
You're correct. I mean, I will say that I live in a blessed county, Campbell County. We live right across the river, even from Ohio and Kenton County and Boone. We have like the Life Learning Center. So we have a lot of resources available in my area. So if there are resources that a defendant needs, I will even mention the Life Learning Center. They offer all kinds of classes. So if we have the services and there's a need, we definitely try to point them to do these types of things. Or if a defendant's already in the family court system, I'm not going to order them to do a lot of classes that the family court's already ordering them to do, because I don't want to overburden a defendant to do more for me that he's already doing for the family court. But if there is no family court and there is needs and I see it, I will order them to do certain things. Life Learning Center, go complete that. But other communities just don't have those services available. Like Campbell County Jail, I know we have a life skills 101 class that's offered in that jail. So defendants can sign themselves up for that and take that type of class. But parenting classes and even like anger management classes, a lot of these classes are only offered online. They're offered by third-party persons, and they're expensive. And then there's really no evaluation as to how many classes they need. Do you need one anger management class? Do you need 5? Do you need 10? If you order 10 because that's the next step up of the program, are you just really benefiting a third person to get a bunch of money out of a defendant who doesn't need 10 anger management classes? So how many parenting classes they need, how much money they should spend. Those are all things that we don't have offered through probation and parole. I agree that we don't have these services that are designated probation or parole services.
Thank you. I get the point.
All right, this time, no further comments. What? Okay, Senator Carroll,
And
another question.
Just in closing, Mr. Chairman, out of respect to Representative Wilson, I did work on this bill, and I tried to address the issues with the extra hearing requiring a reliance on the PSI, and then I also tried to address the issue with the programming and where I think the language I used as available. So I would ask that if you all are moving forward with this, please take a look at that, and please know that the effort was made to get this bill palatable to the judges, and that's the best I could do after many conversations in trying to address those issues. Thank you, Mr. Chairman.
Thank you. We have 3 more people scheduled to speak. So, Mr. West, please come up. Keep your comments as brief as possible because it's now 9:40.
Thank you, Mr. Chair. What I would like to say about the bill, and this is speaking as a practitioner who has asked for probation for many clients over the last almost 30 years. First of all, this isn't going to give probation to anybody who is prohibited from having it. Your sexual offenders, violent offenders, anyone who is trafficked in any quantity of fentanyl or heroin or anything like that. It's only going to be a few people who are probably going to be C's and D felons at most. They are going to normally, in many counties, be housed at the local jail and go to a place where there's not a lot of things on the inside that can help them. And I say that because right now there are only 3 things that are mandatory that the courts have to consider. One is whether there's a substantial risk that if he's on probation, the defendant will commit another offense. Number 2 is whether there are programs on the inside that will help that aren't on the outside. And then the third one is whether or not the probation would unduly depreciate the seriousness of the crime. So with respect to Senator Wheeler's question about a 2-tier system, if I have a defendant and Representative Wilson has the co-defendant, his is a family man. He goes home, he's got a wife, he's got a kid, and mine doesn't. And they're charged with theft, and the reason for the theft is driven by they have a substance use problem. As the attorney for the person who doesn't have a family, I can offer rehabilitation for 30 days in a residence away from the home that he can't. If there's not one in Madison County, which is where the case is, but he can go to Boyd County, I can offer to the court he can go to Boyd County. Mr. Wilson can't. If my client is working, I can pay more in restitution than his client can because all of my money, my client's money, isn't going to care for a family or a child. These are things I can marshal under the current things the court shall consider that Mr. Wilson can't. This adds one more shall, but it doesn't trump the other shalls. It doesn't require a court to make this person come out. And what it does do is it gives them more information than they otherwise have today. This bill as written gives them the opportunity, if I raise the issue, that Mr. Wilson raised the issue that his client's caretaker, they get to look at neglect and abuse records they can't otherwise. So it gives the judges more information than they had. And judges can only make decisions based on the information that's put before them. So I do think there's a need for this. Attorneys will put in evidence on the things that they know the judge have to consider, and then the judges can consider it from there. Thank you.
Senator Wheeler.
I get what you're saying. With all due respect, let's not create a false picture here. 90% of the time, these people are on public assistance of some sort, and they're not really out there working to provide for their child. If they were, they probably wouldn't be where they're at in the first place. So I'm going to vote for the bill, but we don't need to sit here and create a bunch of false pictures in committee about stuff that's not really going on, and everybody out there really knows it.
If my client's that way, I'm not going to file the motion for caretaker. I'm going to be selective to make sure that when the judges open up those files, what I say is going to be there is going to be there.
Thank you, Mr. West. We have two more people that have signed up, Brittany Harrington and Gavin Harrington. If you could, please try to keep your comments as briefly as possible, but do say what you need to say. Thank you for being here. Please identify yourselves for the record.
My name is Brittany Harrington. Good morning, Chairman Storm. Good morning, committee. Thank you so much for having us today. I've obviously prepared something, and I've practiced over and over and over, and I'll keep it really short because I want you to hear from Gavin. I'm a person in long-term recovery, and every single time I entered a courtroom, I begged a judge for intervention. One time I even went in front of a judge for a bond revocation, and my reason was I wanted to be home with my child. The words from the judge were, "You should have thought about your child prior to committing a crime." And while that's true, I was very sick. Gavin was 2 when I became incarcerated. I spent a year in Kentucky jails bouncing from institution to institution, trying to make sure my 2-turned-3-year-old remembered me. The only reason he knew I was alive is because my mother kept a picture by his bed that he said goodnight to every night. It's hard to keep a 3-year-old engaged on a 10-minute jail call. On December 8, 2015, I made parole to a long-term treatment center. Ironically, 11 months prior to that, I'd stood in a courtroom and begged a judge for this intervention. December 8th, 2010 was also Gavin's 4th birthday. It was the first time that I'd seen him in almost a year. The ride to treatment was 30 minutes. We left Davies County Detention Center and I landed in Warm. It's a treatment center in Henderson, Kentucky, and the whole ride he touched my face because he couldn't believe I was real. I didn't take that for granted. I'd signed up for everything the place had to offer, every parenting class, every extra class, and it paid off. On March 3rd, God willing, I make it, I'll celebrate 16 years in long-term recovery. And since 2012, I've worked really, really hard to help mothers like me navigate reentry. I created a reentry program called First Day Forward that's active in 5 Kentucky jails today. Guys, the years of destruction, the years of generational damage that incarceration causes to families is worth a few minutes of consideration inside of a courtroom. And I'm begging you today to please consider this bill and consider the impact that just one question has in a courtroom. Thank you, and I'm sorry. Thank you for having me. And this is my wonderful, beautiful product, Gavin.
Good morning. My name is Gavin Harrington, and like 1 in 10 kids in Kentucky, I'm the child of an incarcerated parent. I was very young when my mom went to jail, so I don't remember everything. But I do see how hard it is for her to still talk about it. Every time she tells the story, I can see the pain come back. I was 2 years old when I went to live with my grandparents. I remember missing my mom. My grandma had to make me say goodnight to her picture every night. I used to run to the mailbox hoping there would be a letter every single time. I remember visiting her in treatment. I didn't understand why she couldn't come home at the time. I just knew she was gone. My mom wasn't a bad mom. She was sick. And the punishment she received just didn't hurt her. It sentenced her too. It sentenced me too. This bill gives families a better chance. It lets parents get help while staying connected to their kids. I'm here today because my mom eventually got the help she needed, but it came too late for too long. Other families deserve better timing. Please support the Family Preservation Act and Accountability Act. Thank you so much for your time.
Thank you for your time, and thank you for being here today. Senator Adams, if you and Representative would like to come back to the table. I don't see any further questions. This time I'd entertain a motion on the bill. We have a motion. I'll make the motion.
Second.
We have a second. Mr. Secretary, please call the roll.
Senator Carroll.
I'm going to be a no, Mr. Chairman, if I might explain.
Yes, please.
I hope we can get to a point where there can be a meaningful piece of legislation. I think there is a lot to be done to actually make this work. I'll be a no.
Senator Deneen.
I'm an aye. Can I explain my vote?
Yes, please.
I'm an aye at this time. I would like to look forward to the floor amendment where I can review that and to see what those additional support systems would be in conjunction with our judges and our courts. So I do reserve that right to change my vote on the floor. But at this time, I do want to see this bill move forward. I am a true advocate of some of the work that our specialty courts are doing in regard to substance abuse and our veterans courts and the frameworks that they put in place to ensure that those that do participate not only qualify for it, but they have continual updates and progress reports in those frameworks that I'm seeing great success with those veterans that are doing those things, and I would like to see some of that extended to some of these individuals that qualify. So thank you for bringing the bill.
Senator Neal. Senator Nemes.
Aye.
Senator Reed.
Explain my aye vote.
Yes, please.
I find myself somewhere in between make criminals scared again and my campaign promise of faith, family, and freedom. And I look forward to, as the bill goes through the General Assembly process, seeing amendments that may make this bill even better. And in the interest of justice for all, I vote aye.
Senator Stivers. Senator Thomas.
Mr. Chair, I'd like to explain my aye vote.
Yes, please.
Mr. Chair, when we talk about legislative policy in general and criminal justice policy in particular, it's often a balancing act. So we've got to balance the risk of reoffending and recidivism and potential harm to society with the rewards of the person getting a second chance and coming out and being a productive citizen. So there's that risk and reward balancing act that we've got to maintain. That's what we're doing here, and my sentiment tells me that we should always err on the side of promoting the family first for reasons I've already articulated. There's no question that if you look at the Bible that Representative Wilson was talking about, that's really one of the core foundations of our society, the family unit. And so, the requirement of another hearing for the benefit of preserving the family, I don't think it's really challenging for us to ask. I look at the reward that we saw from our witnesses here today, and that's a risk reward to me worth taking. I'll look you in the eye and tell you that. And so for that reason, I'm an aye vote here today.
Senator Wheeler.
Mr. Chairman, explain my aye vote.
Yes, please.
I do have great concerns about this bill, but I do have great respect for the sponsor, and she has shown a willingness to work through this, to try to get this right. I know the intention is not to place any additional burden on the judicial system, although based on the testimony of Judge Ward, that does appear to be an unfortunate consequence. But I do think that we really do need to reflect when passing these types of bills that we need to be a compassionate society, but there's also such a thing as false compassion. I became recently aware, I don't know how he popped up in my Twitter feed one day, of Bishop Fulton Sheen. Apparently, in the 1950s, he had the second most popular television program in the United States, and one of his most famous things that he would talk about regularly is false compassion. And false compassion is when you don't have compassion for the mugged, but to the mugger. Not to the murdered, but to the murderer. But when you go down this slippery slope, you end up with a society that, frankly, no longer has a firm direction, that no longer has a judgment on morality, that it all becomes, again, relativism, where you have no definite lines that really form the foundation that allows people to have good families, that allows people to have stable families. And when you look in a birth registry and a newspaper and half the kids don't even have a father named, there's a problem, and yeah, that is sometimes has to do with drugs. I'll agree with that. But that really has a problem with the fact that we tell these people that, well, what you're doing is a sickness. It's not really a morally bad choice that you have made. And it absolutely is that. And yet we seem like we have fewer and fewer consequences for those choices. So out of respect for the sponsor and the intent of this bill, I am going to vote aye, but I do have great concerns about the path we're heading down.
Chair Storm.
I'd like to explain my yes vote. I somewhat disagree with my co-chair. I think he's a great legal mind, and but I do think that we have safeguards here. This is not available to misdemeanor offenders. This is only for felonies. So we're basically saying these folks that he's concerned about, and some of our other colleagues are concerned about, it's this small segment of society, and they also have to qualify as a caregiver. So we're not talking about the whole swath of society, just a small segment, but also we're excluding violent offenders. We're excluding individuals who have perpetrated domestic violence. We're excluding individuals who perpetrated crimes against their own children. We're excluding anyone where a statute would prohibit it. And so I also agree with the comments that my colleague Senator Dean mentioned, where they're so successful in all these other areas, drug courts and veterans courts and things of that nature. I wish they were in every community, because if we can help one child, if we can change one life, I think that's the most important thing. And lastly, I'll just say this: if it's already happening, I don't see a problem codifying what's already happening in the courtrooms. We've heard from these judges that they already consider these things, and these are excellent judges. I've worked with them in the past that have come to this table today, and so I know they're sincere. But in the same sense, what if there's some out there that aren't considering these things like they are? And so for that reason, I vote aye.
Mr. Chairman, to the extent I did not mean to imply that this was available to muggers and murderers. Okay, so I do want to make that clear for the record. I was simply using that as a point and quoting an excerpt from the speech. So that's.
Yes, Senator, thank you. Thank you. At this point, with 6 yes votes, 1 no vote, Senate Bill 122 passes and will be reported with favorable expression that the same should pass. Thank you. Thank you. All right. Now we have, next on our agenda is Senate Bill 48, an act relating to mandatory reentry supervision. That is my bill. I'm just going to remain here and present that very briefly. So let me flip over here. Mandatory reentry supervision exists so that no inmates would be released from prison to communities without monitoring and support. We've already heard from Judge Ward today about some of those supports that are there or should be there perhaps, and perhaps they aren't there because probation parole doesn't have the authority necessarily. However, the Senate Bill 48 addresses an issue that occurred with a young man named Jordan Wells. I believe he was 23 years old. He was shot on March 30th of 24. He died on April 20th of 24. And what this bill would do, very simply, if you have a copy of that in your packet, on page 1, beginning at line 10, it would basically exclude any individuals who have previously been convicted of 2 or more offenses that would classify him or her as a violent offender. It would also make sure that individuals who have been recommitted to prison for a violation of probation, shock probation, parole, or conditional discharge are also ineligible. And then lastly, on page 3, beginning at line 9, I like to see data. I like to see empirical evidence of programs, if they're working, if they're not working. Again, trying to go back to some comments that Judge Ward mentioned, and make sure that these things are successful or not. So what we've asked in this legislation to do is that the Legislative Research Commission will be able to compile this information and regarding the mandatory reentry supervision program and present that to the interim joint committees. The reports due each year, and so I think the last time a report was filed, staff can correct me if I'm mistaken, but I think that was in 2015. So again, we're trying to make sure there's accountability for these individuals and the program itself. So At this time, if there's any questions. Oh, yes, Senator Carroll.
Thank you, Mr. Chairman. Recently, there was a domestic violence related murder in Paducah. A young woman by the name of Stephanie was murdered. It brought up a lot of issues within our community, and I was advised of a particular case that had taken place, and it was related to this mandatory reentry supervision. And it was a domestic violence case. I think there were 3 separate charges that the spouse had been convicted of. Each one of them was not considered a violent offense simply because of the degree of the offense. I think it was strangulation, maybe assault. And as a result, this individual was sentenced to 7 years. I think he got out in 2 years. The victim was not notified prior to release. There was a breakdown in the Vine system. And so, Mr. Chairman, the point in all of that, I wonder if we need to take a closer look at this and the qualifications, and is it restrictive enough? In this particular case, not a doubt in my mind what I know about that case, that offender should not have been let out earlier. I think there was a couple standoffs involving law enforcement that he was involved in, and he ended up getting out on this program, and I was very uncomfortable with that when I heard about it. So I hope we can have discussions on possibly making some additional changes to this to tighten it up a little bit. Thank you.
Thanks, Senator. I'm not sure the actual facts in that case, but I'm not sure if the person was released on discretionary parole or not, but we'll look into that. And then I know you also mentioned Vine, and we've had some interim testimony, I believe, in this committee regarding that notification system and anomalies that have occurred when victims haven't been appropriately notified for whatever reason. So again, we need to make sure we're taking care of those victims. Seeing no other questions at this time, I would entertain a motion on the bill.
Motion.
We have a motion and a second. Mr. Secretary, please call the roll.
Senator Carroll.
Aye.
Senator Deneen. Senator Neal. Senator Nemes.
Aye.
Senator Reed. Senator Stivers. Senator Thomas.
Aye.
Senator Wheeler. Chair Storm.
With unanimous vote, Senate Bill 48 passes, and we're reported favorably with the expression the same should pass. And Senator Neal, I saw you come in. You were stuck in traffic on the interstate as well. Would you like to record any votes?
Yes, Mr. Chairman. I understand there's been some discussion about some modifications perhaps being dealt with on the floor when this comes up. So I generally support this bill, and therefore I'm going to vote aye, if you permit that, with that understanding.
Would that be on Senate Bill 122?
That will be on Senate Bill 122.
Thank you, Senator.
Thank you.
Seeing nothing else, we are adjourned.
Good job.